committing their lives to helping us through this whole legal process. Robert Hafel is with us. He'll be the moderator. He's with Motley Rice. He spent 30 years practicing complex civil litigation, asbestos, tobacco, mass torts, and he's got 6,600 family members and survivors that he's working with right now. So Robert, we appreciate you being with us. Duke Maloney is a partner at Kreindler & Kreindler. He's a critical member of the legal team immersed in the 9/11 terrorist litigation with the Saudi Arabian government. John Eubanks couldn't be with us today, but John will be with us in person, but he will be with us via live stream, so we're going to pipe him in shortly. He's a member attorney with Motley Rice, extensive experience in terrorist organization work and terrorist financing and in going after them. He's working on litigation designed to bankrupt the financing of terror. And then, of course, Terry Strada. Terry's not an attorney, but boy, is she a fireball. I kiddingly said to her, Mary and she have the same DNA as far as, kind of kicking butt and really making things work. So Terry's done a lot of work. A mother, a widow, a special interest advocate. I see her on TV a lot. She's after this Lib tour and really making a difference. And she's really all over JASTA and so forth. So we're going to have a discussion that Robert will lead. We'll have time, I hope, for some Q&A. And then we actually asked folks for questions, and we've got a handful of questions that we're going to serve up. One thing we're not going to cover today is Gitmo. These folks are not involved with the Gitmo topic, but Voices has reached out, and we hope to have a Gitmo discussion. We'll make it available for folks online to come into over the next couple of months. So, Robert, if you'd all welcome Robert.
Thank you, Frank. Thanks for the intro. You've made me sound very old. Do we have, all right, you have the slide, and is it the green button to go forward? Okay.
And we got John.
And we got John as well. Great. That's important. John's there. Hi, John. Well, good morning, and thank you, Mary and Frank, and the very hardworking staff at Voices for inviting us back, and for the excellent symposium that you all put on. Thank you very much for that. On behalf of each of us on the panel, thank you to each of you, those in the room and those who have joined us remotely. We are appreciative of your interest in the litigation and your advocacy to help us out, as well as the appreciation for the advocacy work that we've all been doing. I think I speak for each of us in saying that we're very honored to do the work that we do for you. I'm Robert Hafel, as Frank said. I'm from the Motley Rice law firm that represents a number of the plaintiffs in the 9/11 litigation venued in New York as inmate terrorist attacks on September 11, 2001, what we have termed MDL 1570. And I'm also one of the members of the plaintiffs' executive committee that helps to coordinate the litigation on behalf of the plaintiffs. With me today, as Frank said, is Andrew Maloney from Kreindler & Kreindler, that also represents a boatload of the plaintiffs in the litigation as well. And also on the dais with us, we have Terry Strada, who's the national chair of the advocacy group known as 9/11 Families United. And joining us on my left, your right, up on the screen is John Eubanks. He's joining us from Charleston area, and he's from Motley Rice with me. So with my time today with you, my goal is, as in the past years, to run through what's happened in the litigation since last year, to know what's happened throughout the last 12 months. Essentially, one caveat is for everything that's Iran related, I'm going to leave that to Mr. Eubanks. So setting aside the discussion regarding Iran issues, the 4 bullets that are identified up on the screen here are principally the activities over the past year that the courts and the lawyers have spent their energies and time doing. That's the Daubert motions, which is the motions that limit or strike expert testimony in the litigation. The Sudan's appeal, we'll talk about that. Sealing and unsealing issues in the litigation, as well as by far the subject of most of the attention this past year has been Saudi Arabia's motion to dismiss the litigation. Let's look first at what happened regarding the Daubert motions. With regard to the Daubert motions on behalf or related to the Saudi part of litigation, nothing's really happened in this past year for those. The motions were briefed, and that was completed in August of 2023, and we're still waiting the court's decisions on those rulings. With regard to the motions in the charity part of the litigation, recall that there was a previous Daubert decision in April of 2023 where the court struck one of the experts, one of the defense experts, and limited some of the other experts. In July 2023, the charities filed some additional motions against 3 of the plaintiff's experts, and we're still waiting for a decision on that. The motions in October, I think it was, the motions were fully briefed, and so the status of the motions on the Daubert issues is essentially we're waiting for the Kingdom's Daubert motions to be resolved, and we're waiting for the charity supplemental motion to be resolved. Another area of activity this past year concerns claims against Sudan. First, just a reminder that Sudan filed its motion to dismiss, which the court denied in August, just before we were here last year. And in that decision, the court found that the plaintiffs had stated a plausible cause of action against Sudan, and that the court had jurisdiction to decide those claims. The day after we were here last year, September 11th, 2023, the Sudan appealed that decision, tried to get the decision tossed out, and overturned the decision. So then in early December, plaintiffs, we filed a motion to dismiss that appeal, saying it was improper, and the court heard oral arguments in April of 2023, and just last week, September 3, the appellate court agreed with us and dismissed that appeal. So essentially, that puts back Sudan into the litigation in front of the district court. I think the next, I'm getting a little ahead of ourselves, but probably the next thing would be Sudan needs to answer the complaint that's been submitted against them, and then we're off to the races against Sudan, I suppose. Another area of attention over the past year concerned efforts to move much of the record, in particular the record related to the claims against the Kingdom of Saudi Arabia, to put that into the public eye, get the information out on the public docket. During the discovery and the litigation, what's happened is many of the filings got filed under seal so we could move the litigation forward, but there were 2 protective orders in the case. One that was an umbrella protective order that covered everything that was, well, not everything, it covered things the parties claimed to be confidential throughout the discovery period. So the discovery period is essentially when people are, when the parties are asking for information and providing information pursuant to those requests. During that discovery period, if the parties identified something as confidential, it ended up getting filed under seal. The other confidentiality or concerned information that we received from the FBI, and much of that information ended up being under seal as well. What happened is, this year, once the case shifted from a discovery phase, where the parties were exchanging requests for information and responding to them, to a more substantive phase where the court was adjudicating issues on their merits. For example, the motions to dismiss, the Daubert motions, motions to strike evidence. The standard for sealing got raised, and it was basically the information that the court was being asked to consider substantively. There was a very strong presumption of public access to that information. So with this new phase came this strong presumption of public access, and the court has explained it this way. When a court makes decisions that affect the merits of the party's claims, that's a formal act of the United States government in the federal court. And when that happens, absent some strong exceptional circumstances, the information has to be reviewed by the public, or available to the public, so the public can see it and make sure that the courts are acting appropriately. And this year, when the court turned from deciding issues affecting the merits, or when they turned from deciding the things that were on the discovery issues to deciding things that were meritorious, like the Daubert motions and the motions to dismiss, that started to change that, elevate that strong presumption of public access And we asked the court to take note of that and start aggressively putting things into the public eye where it could. An early instance where we asked the court to apply that strong presumption of public interest or public access happened when Saudi Arabia, just after, I think it was just before the New Year, in December, late December, they filed a motion to strike portions of our opposition to his motion to dismiss. And that motion to strike evidence is itself one of those adjudications that substantively affected the merits of the case. And so when they did that, it triggered that strong presumption of access. Attached to Saudi Arabia's motion, they included a number of items that had been filed under seal. And when they did that, we went to the court and said that this public interest, this public access interest is raised now. After the court decided the motion to strike, the court came to the parties and said, do you think that the decision that the court has made should be public, or is there a reason to keep it under seal? And in response, the plaintiff's lawyers universally went to the court and said, look, the decision needs to be unsealed, but not only the decision, but everything that you looked at for purposes of making that decision has that strong presumption of public access as well. And there were some arguments on that over the course of a few months, and ultimately what happened is the court issued a decision that started to release certain pieces of the information. And that was essentially the start of flipping to get things out into the public eye. After the motion to dismiss was briefed, fully briefed, and much of the stuff was still under seal, the parties began a long process of reviewing voluminous amounts of the seal filings to determine what could be unsealed from those and put on the public docket. But the process was creeping along very slow. When the court set the original motion date, or the argument date, which it was originally set in July 10th, to address Saudi Arabia's motion to dismiss, it became clear to us that we weren't going to get through everything to review it, to figure out what could be put on the public docket, and that caused some conflict, first with the ability to argue the case publicly, but also with the ability for the public to review what the court was looking at to make the decision. What brought that conflict to the court's attention, or we brought that conflict to the court's attention, and the court ordered briefing on the public access and put off the motion date from the 10th to the 31st and set a date for July 17th to address the arguments held on the public access issue. Part of what seems to have driven the public access issue may have been that in the days leading into the oral argument, some of the media entities you see listed up on the screen here appeared in front of the court to urge the court to take notice of the public's interest, take notice of the need for public access to the information, and to urge the court to unseal the court filings on the motions to dismiss. After July 17th arguments on the public access issue, Saudi Arabia, the FBI, and a number of other third-party witnesses sought to keep the evidence sealed or redacted. We appeared, we argued, we called the court's attention to the heavy burden that those who were seeking to keep things sealed had to meet in order to keep things under seal, and urged the court to keep in mind the importance of the access to the information and the upcoming arguments, and the importance that that information remain public. On July 29th, just days before the oral argument, or scheduled to happen on the 31st, the court issued an order on the public access issue, which is a bit more nuanced than I'm able to address to us here today. But in general, what it was it basically struck all of Saudi Arabia's arguments on sealing information, removed the redactions that Saudi Arabia had proposed, and allowed much of the FBI's proposed redactions to remain in place, but released information about 30 high priority individuals that were identified in the information, which essentially allowed us to move forward with the oral arguments publicly, so everybody could cite what was in the record, the public could hear what was being cited, but We still have to go through the documents now to make the redactions that are consistent with what the judge's order was, and we're still working through that right now. The last area of attention over the past year, and by far the area that's consumed most of the party's time and attention, concerns Saudi Arabia's fourth attempt to get out of the litigation. Its fourth motion to dismiss was filed in October of 2023, and briefing was complete in April of this past year, 2024. And then the court heard oral argument, as I said, on July 31st. We can't address today all of the evidence in opposition to Saudi Arabia's motion to dismiss. There was thousands of pages submitted to the court, hundreds of exhibits. The oral argument took hours to do in front of the court. But I do want to offer a few samplings from the newer evidence. Before showing the examples, though, let me address two preliminary points. The first concerns Saudi Arabia's constant refrain that it was exonerated. Its refrain comes from one sentence, or at least one part of one sentence, in the 20-year-old 9/11 Commission report. In the box up here behind me, you see that sentence, and looking at that sentence in the box on the screen, Saudi Arabia claims it was exonerated where the Commission wrote in the text that's underlined in that box, where it says that we have found no evidence that the Saudi government as an institution or senior Saudi officials individually funded the organization. And that one sentence keeps getting refrained by the Saudis, and frequently in the reports about it, they hone in on that sentence. But there's a number of flaws with that view. First, it ignores the sentence that's highlighted here in the same sentence just before that, where it says Saudi Arabia has long been considered the primary source of al-Qaeda funding. It also ignores text that's, I didn't include it on the slide, but it ignores text that follows immediately after that in a parenthetical, where the Commission's report confirmed, quote, the likelihood that charities with significant government sponsorship diverted funds to al-Qaeda. It also ignores, as it is recorded in the sentence below from the 2016 New York Times report, the Commission staffers made the point that the sentence was carefully crafted to not rule out the possibility that less senior Saudi officials aided the hijackers. The third serious flaw with the Saudis' refrain is that it ignores the 9/11 commissioners who actually were asked about the exoneration claim denied it. In an affidavit from 2012 from Commissioner Carey, he says, quote, it's fundamentally inaccurate and misleading for the kingdom to suggest the 9/11 Commission's investigation exonerated them. And Mr. Carey has repeated and reiterated that in a recent podcast as well. And in 2015 affidavit, Commissioner Lehman said, quote, the 9/11 Commission did not exonerate Saudi Arabia of culpability for the events of September 11, 2001. And in a statement published in 2016 in Real Clear Politics, Commissioner Tim Romer put it quite simply saying, the Commission did not exonerate the Saudis. The second preliminary point, before looking at some of the examples of the new evidence, concerns the identity of one of the individuals that's throughout the documents that we've used. And that's a Saudi who's named Omar al-Bayoumi. You see up on the screen here a report from a FBI report from June of 2017, more than a decade after the 9/11 Commission wrapped up, which was made public in redacted form following the 2021 executive order, presidential executive order that directed the declassification of much of the 9/11 evidence. And in this report from 2017, the FBI confirmed something that was suspected early on, but was confirmed in 2017. Namely, as the text up here says, in the late 1990s and up to September 11, 2001, Omar al-Bayoumi was a co-optee of the Saudi General Intelligence Presidency via then Ambassador Prince Bandar bin Sultan Al Saud. Put differently, in 2017, the FBI confirmed that Bayoumi worked for a spy agency for the Saudi government while he was here in the United States, and the 9/11 Commission didn't have that information. Now, keeping in mind that Bayoumi worked for Saudi spy agency, let's look at a few pieces of the new evidence uncovered in the 9/11 litigation. Much of the new evidence comes from a trove of documents that we received from Metropolitan Police Service, or MPS. They gave it to us in 2022 and 2023, which they got when they raided Bayoumi's home in the UK shortly after September 11, 2001. One of the items from the British authorities came from Bayoumi's house was a yellow notepad on which Bayoumi had sketched an airplane in blue ink, and above the airplane he had written out mathematical equations. And you can see up on the right-hand side of the screen, you see a little clip of that sketching, showing a drawing of an airplane with a calculation on a diagram with the words distance from the plane to the horizon on the horizontal axis of the drawing, and on the vertical axis you see the words height of the plane from the earth in miles. Now, first thing here is Bayoumi has admitted that this is his drawing, it's his handwriting. Although he didn't have an explanation for why he drew this, an FBI expert, a pilot, has reviewed it, and after considering the drawing and the calculations, he said he couldn't think of any other reason for the equation other than to calculate the descent rate from a given altitude. And an expert pilot that the plaintiffs retained to give an opinion, he put it this way. About the sketching and the calculations, he said they're consistent with the preparations made as part of the planning for the 9/11 attacks, and they were made to assist the 9/11 hijackers in carrying out those attacks. Also included among the items the British authorities seized from Bayoumi's home were a host of video recordings that Bayoumi had in his home. And one of those videos that Bayoumi had, he had handwritten a label on it that indicated it was from a trip to Washington, D.C. in June and July of 1999. Now, we know, for example, from the 9/11 Commission report, that this trip happened during a period when Al-Qaeda was selecting targets from the target package to figure out which targets to target. One of those was the U.S. Capitol. We can't watch the full hour of the video today, although I think Mr. Bowen may have a few still shots from those. But I think you can see at least parts of it on the 9/11 Families United's website, is that right? So that's www.911familiesunited.org. Those people who have looked at it, most of them, the refrain that I keep hearing is that they describe the video as chilling. In the video, for example, Bayoumi records extensive footage of the U.S. Capitol, the interior columns, entrances, exits, security posts, a model of the building from above so you can get an aerial view of it coming in, the building's spatial relationship to nearby landmarks like the National Monument, the National Mall, the Washington Monument. He notes how close the Reagan Airport is to where the Capitol is. He directs his comments to his, quote, esteemed brothers. He greets his audience with comments like, peace, mercy, and blessings of Allah be upon you from the United States of America, Omar al-Bayoumi from the Capitol building. Once again, my esteemed viewers, I greet you and I welcome you from the Capitol Hill. He references, quote, a plan. He injects extremist commentary into his narrative on the recording, including referring to these, the people at the Capitol as demons. So the Saudis have argued that it's a tourist video. And I think when you watch the video in its entirety with the idea behind what's happening in the video, you can understand it's closer to a terrorist video as opposed to a tourist video. After seeing the video, two national security and intelligence experts said it wasn't a tourist video. Richard Lambert, former chief of the FBI's espionage section and its counterintelligence division, he characterized the video as a, quote, pre-operational surveillance video of the intended target, the Capitol. Former CIA Deputy Director Mike Morrell said there is no doubt in his mind that's a casing video for some sort of terrorist attack, and that Al-Qaeda tasked him, Bayoumi, to do the casing video. Morell, who on September 11th, 2001, was the CIA agent who gave the daily briefing to the President of the United States, said, if I had seen that video, and I did not, I would have shown that video to the President. More video culled from Bayoumi's home video collection includes video from a welcoming party that he hosted for two of the hijackers when they first arrived in the United States. 2 weeks after helping the hijackers get settled into San Diego, helping them to get housing and helping them to get financial banking accounts, he held a welcoming party at the terrorists' home, which was right next to his home. And Bayoumi asked somebody to film the welcoming party. We received video from that welcoming party. Some of it we got from the FBI, but by far we got many more clips of it to allow us to compile an entire story of what happened at that party. The version of the video we received from the British authorities was much more complete than the shorter version of the clips that we received from the FBI. We don't have time again today to go through the whole video, to watch the full video, but using digital imaging analysis and after using the ability to translate and insert the subtitles to painstakingly assemble the video together, the court has now seen the fullest account of that party that's ever been seen, and so that never before seen details of that party could be addressed publicly in the hearing on the 31st. The translation and the analysis of the full video confirms that Bayoumi and the folks that helped the hijackers get acclimated, they held this party so that they could introduce the hijackers to like-minded community, like-minded religious leaders who could be trusted to look after the hijackers and essentially cocoon them into a protective support network. So that's essentially where I have to give you an update on what's happened this past year. But before I step aside, I'm going to turn it over to Mr. Maloney in a minute. He's going to have perhaps a few more details about some of the items that we just discussed. I did want to put a plug into about an item that we discussed last year that Terry Strada is going to address a little bit more today, and namely that's I need to underscore the importance and the need for your full support to enact the Ensuring Justice for Victims of Terrorism Act, or EJVTA. Terry's going to address it more, but I did want to underscore the value of making sure that the legislation is in your mind and that you give you support. With that, I'm going to ask Mr. Maloney if you can come up.
Thank you for having me back again. I was here last year, and I think I expressed a degree of optimism about the case and where we stood. I can tell you today, I feel 10 times more optimistic about the case. We've received loads of evidence in the last 18 months, and have really taken huge steps towards ultimately, hopefully, winning this case. I feel very good about where we are. I'm going to tell, Robert covered a lot of it. I'm going to probably just give you some more of the details and the highlights. I'll be much briefer, I think. By a show of hands, how many of you were able to attend the oral argument on July 31st at the courthouse or listen on the telephone? Well, you know that we were well represented, all of you and all of us, by Gavin Simpson, who's here in the audience here, by way of Scotland, who's joined the team a few years ago, who's worked extremely hard. He worked around the clock, first going over to London and convincing the courts there and the Metropolitan Police Service to give us access to a treasure trove of evidence that they seized from Omar Bayoumi within 2 weeks or 10 days of the 9/11 attacks. That information was turned over to the FBI. Where it went after that, we don't know. As you heard from Mr. Hafley, Saudi Arabia and its lawyers have relied heavily on the 9/11 Commission report, which was published in July of 2004. There's a lot of good and helpful facts in the report, but their analysis and conclusions are very flawed. And they're flawed in part because they didn't have a lot of this evidence that we now have. Some of the stuff is in this report is directly contradicted. For example, on page 218, they claim that Bayumi, I'll read you the sentence because some of you are familiar with it if you've read this report. Our investigators who have dealt directly with him, Bayumi, and studied his background find him to be an unlikely candidate for clandestine involvement with Islamist extremists. Nothing could be further from the truth that we now know. Mr. Hafley showed you the FBI report from 2017 or 18 that concludes that Bayumi was in fact a co-optee of Saudi intelligence and reporting to the embassy. Why weren't we told this much earlier? Why did the 9/11 Commission make that statement in this book that the Saudi lawyers still to this day rely on heavily? One of the things I want to show you is there's another passage in this book about the welcome party for the two hijackers, Hazmi and Nidar, when they arrived in San Diego at Bayumi's invitation. You may remember that Bayumi met them at a cafe up in Los Angeles and had them come down to stay in San Diego, and Bayumi got them an apartment a couple of doors away from his own apartment, signed their lease as a insurer, helped them open a bank account, made the deposit for their first month's rent, did a lot of things for them, and introduced them to the community in San Diego. Within 2 weeks of their arrival, Bayumi orchestrated a welcome party for the hijackers. That's described very briefly in the 9/11 Commission report. That was known back in 2004, but what was not known was the extent and the reason for that party. And the 9/11 Commission got it wrong. Why they got it wrong is still puzzling to us. I can only assume that they didn't get the full video that we now have, because when the FBI eventually gave us that videotape of the party, it was a much shorter edited version. We think that's probably the version that the Commission received. But the full video that Mr. Simpson was able to get from the MPS that we have now offered as evidence in the court shows a much more extensive party video. The 9/11 Commission made the wrong conclusion that Hazmi and Nidar stayed in the back room. They weren't really participating in this party. Nothing could be further from the truth. The reason the party was to introduce them to the San Diego Muslim community. That community, they all know each other. I'm going to show you just a couple of slides from that video and you'll see what I mean. Everybody in the room, this party was hosted in Hazmi and Nidar's apartment. Everybody in that room knew each other except for the two new people. That's Hazmi and Nidar, who had just arrived. Oops. So you can see on the screen where Bayumi says, and we are welcoming the brothers, in fact, whom we have not yet had the pleasure of meeting. He's referring to Hazmi and Nidar, who are, Nidar is standing right behind them and Hazmi is sitting two persons away from him, looking out at the group that's about to have a dinner party together. Bayumi instructs everybody in the room to introduce themselves to the two future hijackers. They're the only ones who don't know each other, so he's asking everybody in the room to state their name so that the brothers will get to know his name. This was the support network that Bayumi was orchestrating for the two hijackers, because Bayumi couldn't be there every day at all times to babysit the hijackers. He needed other people in the community, like-minded people in the community, to help the hijackers, to purchase an auto, to get a driver's license, to get flight lessons, to essentially get involved in the fabric of the San Diego Muslim community. So he was asking these people at this dinner party to help him do just that. Here, Bayumi's referring to Nawaf. That's Nawaf Hazmi, who is sitting right next to Bayumi's own son that you see in the picture in the lower right. You don't see Nawaf. He's actually, they tried very hard not to actually film the hijackers. They filmed everybody but the hijackers, but you can see the hijackers in various parts of the video. So the 9/11 Commission only identified, I think, 5 people that attended the party. But as you can see from here, we made painstaking efforts, Gavin Simpson in particular, with translators and interviewing other witnesses and really essentially doing the work that the FBI should have done many years ago to identify each and every person that was at that party. This graphic shows you the names of those people, so we know who they are, we know what they did, and each of them played a particular and critical role in supporting the hijackers. A special note, there is another Saudi government official in the room, Sheikh Mohammed Al Khattani, and he is a Ministry of Islamic Affairs official. When Judge Daniels asked Mr. Kellogg at the oral argument about Khattani, I think it was Greg Rapway's, his junior partner, he claimed he didn't know who he was. He didn't confirm or deny that that was a Saudi government official. But we have investigated and found out he is, in fact, an official. So they have no answer to why another government official for Saudi Arabia was in this room with two hijackers. Mr. Hafley showed you the Bayoumi airplane drawing, we call it. That was recovered from Bayoumi within 10 days after 9/11. It was given to the FBI. What the FBI did with it, we don't know. It wasn't, there's no report about it by the FBI until I think 2011 or 2012, when Operation Encore agents discovered it in a box. And they said, this looks important. And they had somebody, a pilot, to take a look at it. And as you can see, Bayoumi, we deposed Bayoumi a few years ago, he was asked specifically, was this his handwriting? He admitted it was his handwriting. He was asked specifically, why did you draw this? What's it about? He said he couldn't remember. He was just trying to figure out distances. In fact, he mentioned the distance between Washington and Baltimore. Aviation experts have indicated that this is a navigational aid that basically, for just pre-planning purposes, of the altitude of an airplane when it could see a ground target at a certain altitude and a certain distance away. And that's what the formula is supposed to be able to tell a pilot. And Bayoumi could not explain why he drew it. A year later, and you may have heard this in open court for those of you who were there or watched, the Saudi lawyers claimed it may have been Bayoumi's 14-year-old son who was in school and doing algebra at the time. Bayoumi didn't say that. That was the argument by the lawyers. And even Judge Daniels picked up on that and said, well, did Mr. Bayoumi say that when he testified? Humana, they backpedaled. They knew that they had made that up out of whole cloth. One of the other really key pieces of evidence that we obtained from the MPS, and frankly should have been given by the FBI, that Mr. Hafley referred to, was the Capitol casing video, which the Saudi lawyers, even as of July 31st at the oral argument, claimed was a tourist video. They ignored and could not explain the narration that Bayoumi gives while he's filming the Washington Mall, approaching the Capitol, and filming inside the Capitol. So Bayoumi narrates the video. And I'm going to show you a couple of slides. I'm not going to play the whole video. We didn't play it in court, but I think many of you have already seen it. It's available. It's in the public domain now. But Mr. Kellogg, Mr. Rapway, the lawyers for Saudi Arabia, could not explain anything about the narration. In fact, I'm going to go through a couple of slides, and one of them, Judge Daniels asked them about specifically. So here's Bayoumi filming. He's approaching the Capitol. We had his Arabic, he speaks in Arabic, and we had it translated, and Saudi Arabia did not challenge the translations. So here's Bayoumi saying, this is from afar, Capitol Hill, which is the American Congress. He says, I will get over there and I will report. I will report to you in detail what is there. Starting to sound more like a report video rather than a tourist video. Then he says, he's giving some more information about the area around the Capitol. For those of you who are familiar, that's the little pond that's below the Capitol. However, I'll provide you with more results of the results soon. These are cars for, I think, senators that are parked there, and he's telling whoever's viewing this video, those are their cars. You said that in the plan. What plan is he talking about? A tourist plan or a intelligence casing video to attack the Capitol? He says when he's outside the Capitol, they say that our kids are demons. However, these are the demons of the White House. That doesn't sound like a terrorist video. Judge Daniels asked the Saudi lawyers, Kellogg and Rappaway, what does this mean? What does this mean when he says that they are demons, the demons of the White House? And all Mr. Rappaway could say was, it's an unfortunate phrase by Bayoumi, it's just a slip of the tongue, mistake. He couldn't explain it. Certainly was not consistent with his theory that it was a terrorist video. And in front of whom? In front of the Congress, there is no power nor strength except through Allah. That's Bayoumi's message to his audience who's viewing his video, that as far as their religious belief that Allah is the Almighty and the American Congress is nothing, and perhaps should be destroyed. And here he is at the end filing his report, Omar Bayoumi from Capitol Hill, the Capitol building. He's reporting to higher-ups within the jihadist group in the Saudi government and Al-Qaeda itself. I think that was the last slide I have. Oh no. Now here he says, "Oh, beloved esteemed brothers, a greeting to you from Omar al-Bayoumi." He's talking to his esteemed brothers, not family members. So you can see from some of this evidence, it's pretty compelling. Mr. Simpson walked the judge through it in the courtroom, and Saudi Arabia's lawyers had almost no answers for any of it. There's even more. One of the treasure troves also recovered by the MPS from Bayoumi was a phone book. I don't have slides of that, but there's a phone book where he writes down the names of over 100 Saudi government officials with their phone numbers, and in many cases, their private cell phone numbers. And lo and behold, we have phone records that we did get from the FBI that show multiple calls between Bayoumi and many of those officials. The evidence is mounting. The evidence is mounting, and Saudi Arabia and their lawyers can't explain it. For years, they've been explaining things as coincidence, to mere coincidence that Bayoumi met Hazmi Mirar in Los Angeles, mere coincidence this, mere coincidence that. But now we have direct evidence that is more than just circumstantial evidence. And the circumstantial evidence is very compelling and admissible at a trial. And the direct evidence is even better. You put the two of them together, we feel very, very good about where we are in this case. Don't ask me when Judge Daniels is going to make a ruling, because I don't know. He has taken his time before. It could be any day, it could be tomorrow, it could be months from now. I do know that whatever he decides, it's likely that the losing side will appeal if we win, and I think we will. Saudi Arabia will take an immediate appeal. They have that right as a sovereign state. Normally you can't do that until there's a final judgment, but in this case, legally they can do that. But it will be a big turning point in the case, a big milestone, if Judge Daniels denies their motion to dismiss yet again, and hopefully talks about some of this compelling evidence that was presented to the court in our opposition. I think that's all I have. I'm open for questions on the panel or afterwards. Thank you.
The next panelist that is going to talk is John Eubanks. He's going to, I think, John, you're addressing mostly issues related to the USB SSD and the Iran claim, correct?
Correct.
So, John Eubanks.
First of all, thank you for the privilege of being able to address you again this year, and I apologize that I'm not able to be there in person. This event is very important to me personally, so I just appreciate that Frank and Mary Fetchit for allowing me to appear by video instead of being there in person. And it's really hard to follow both Robert and Duke as they went through all of what has happened in the past year, especially as it relates to Saudi Arabia, because sometimes it feels like we forget the Saudi Arabia case when we're dealing with Iran, and we forget the Iran case when we're dealing with Saudi Arabia, and we're all part of the same grouping, but that presentation was phenomenal, and also the presentation in court by Gavin, so I have to give him a hand as well. So I'm going to give you a little bit of a thumbnail sketch on where things currently stand with the cases against Iran and also the U.S. Victims of State-Sponsored Terrorism Fund as we near the end of the government fiscal year for 2024. So the government fiscal year ends on September 30th. So one thing I can say definitively is there will be a distribution in 2025. What percentage that's going to be, I'm going to give my best prognostication, but The current balance of the assets within the fund as of August 31st was about $1.22 billion. So the amount of money in the fund is significant right now. They have published previously how much money they have to maintain in the accounts of the fund. So it's around $156 million that they need to maintain in the fund from year to year to cover expenses or conditional payments and any sort of payments that just for one reason or another haven't been able to be paid out. So the way I see it, rounding down a little bit, I think the distribution, if we were having a distribution today, would be around $1,050,000,000. So we're going to assume that there are no additional case deposits between now and the end of this month, which may or may not be the case. And we'll also address another kind of overarching issue, which is the American Victims of Terrorism Compensation Act, a little bit later in my presentation. But if we work with the distribution amount of being $1.05 billion, then that number is split in half, and $525 million is distributed to the eligible 9/11 related claimants, and $525 million would be distributed to the eligible non-9/11 claimants. Now, to put that in perspective, in 2023, I know that there were a lot of people who were unhappy with the distribution that happened in January of 2023. But in that distribution, the fund distributed $50 million to each side. So we're talking about 10.5-fold what was distributed in that distribution. So it's going to be a little bit different than 2023. It's not going to be quite as robust as 2020. But I wanted to kind of let you understand how I got to the figures that I got to. So since the last distribution that happened in January of 2023, I'll leave aside the 9/11 catch-up payment, but the January 2023 payment was the 4th round. So we're looking at the 5th round coming up in probably January of next year. Since then, the fund has received new applications for over 4,800 claims. But the vast majority of those new applications have not been 9/11 related claims. They've been non-9/11 claims. On the 9/11 side, the way I've calculated it based on the numbers that we have, there are 663 new claimants, but I know that 152 of those were for non-national claimants, and the special master has determined that those non-national claims are ineligible for compensation from the fund. Now that decision is being appealed to the special master because it's just plain wrong, but from the perspective of how many eligible claims are in the fund as of now, we're looking at the total number of 9/11 claims being around 12,628, which is an increase of a little over 4% from the last round of distributions. So if this payment is fairly similar to the 3rd round payment in terms of how much money is being distributed, we're not seeing a great drop off in the percentages. So what I've kind of been able to extrapolate from all the numbers that we have in-house and also from the numbers that for the distributions in the past is that on the 9/11 side of the fund, the claims amount to approximately $85 billion worth of claims throughout those 12,000 some odd people. On the non-9/11 side, it looks like they're at around, after going into this round coming up, they will be around 26 billion in judgments or claims values. So it's a little more than a 3-to-1 ratio at the present time, but keep in mind that there was a large increase in the number of non-9/11 claims in this round. That is going to continue. There are a ton of 9/11 or non-9/11 related claims pending in the district courts in Washington, D.C. right now. Literally thousands of claims are pending there, primarily for families of individuals who were killed in Iranian-sponsored terrorist attacks in Iraq. This would be military families, American contractor families, and whatnot. Also, as time is going to go by, you're going to see the American victims of the October 7th attack in Israel be able to bring claims because Iran is the primary sponsor of Hamas. Hamas attacks are state-sponsored terrorism attacks by virtue of the support that Iran gives to them. So what I anticipate, absent any additional distributions or additional deposits, or some change in the number of claims that I don't know about, but I can't really envision that, is that we're probably looking at a distribution that's going to have payments per claimant of a percentage of about 0.55 to 0.6%. I know it doesn't seem like much, but keep in mind that these judgment values that you have in this case against Iran are significant. So a spouse with a judgment of $12.5 million against Iran, if we have a 0.2% distribution, that is still a $75,000 payment. So it's not the large numbers we were hoping to see going forward in this fund, but it's still much better than what we saw in 2023. And again, as time passes, you're going to see that the non-9/11 side, even though they're getting higher percentages this year, possibly next year, I have a feeling there's going to be an equalization somewhere in the next 2 to 3 years where it will either equalize with the 9/11 side or possibly exceed in terms of the amounts of judgments that are pending against Iran and Syria out of those non-9/11 cases. I want to turn to two of the companies that are involved in some of the case deposits. There is Binance, which is a crypto company who basically employed zero safeguards to their crypto exchange that allowed significant funds transfers in and out of state sponsors of terrorism like Iran, Syria, and elsewhere, while also operating in the United States and violating all sorts of laws related to bank secrecy, bank fraud, and whatnot within the United States. So back in February of this year, Binance finally pled guilty and was sentenced to a plea agreed deal of a $4.3 billion payment to various federal agencies and the US government that's paid over 3 separate payments. The first payment was approximately a $900 million payment. Almost all of that initial payment has been deposited into the fund. It was all related to violations of engaging in business with a state sponsor of terrorism. This summer, an additional large payment was made by Binance as part of its plea agreement, but it appears that those payments were related to its role as an illegal money services business that was unregulated in the United States. So, significant amount of money, but the money services business portion of the Binance plea agreement really does not touch upon the state sponsor of terrorism issue. I know we are of the view that once something does touch upon a state sponsor of terrorism, it should go, every part of that case should go into the fund. But that is not the view that the Money Laundering and Asset Recovery Service of the Department of Justice takes, and that is who decides what money goes into the fund and what money does not. Next year, around August, Binance will be making the final payment on its $4.3 billion settlement or plea agreement, and that money is going to deal with their failure to adopt know your customer policies, or basically in June 2008, North Korea was delisted as a state sponsor. It was relisted in November 2017, and the vast majority of the transactions at issue in that case allegedly occurred between June 2008 and November 2017, when it was not designated as a state sponsor of terrorism. They've determined that only a certain portion of bank fraud payments were made during the time period where where North Korea was a designated state sponsor. So they've taken the bank fraud fine, multiplied it by the percentage of transactions in the bank fraud that actually were paid when it was a designated state sponsor, and that's the amount of money that they put into the fund, which was slightly less than 11 million. Now, Both the Binance payments and the British American Tobacco payments are the subject of litigation filed against the fund and against the Department of Justice and Treasury on behalf of a large number of non-9/11 claimants in the fund, and the attorneys who are representing them also represent a very small number of 9/11 related claims as well. So that case that is under the Administrative Procedure Act argues that the fund has violated its statutory mandate by not depositing the entirety of the payments made by both of these entities. We, meaning Motley Rice, I believe Kreinler & Kreinler has also been in support of trying to get those payments into the fund, Anderson Kill and others. We've offered any support that these attorneys might need because any additional money coming into the fund is a win-win for all of the claimants within the fund. Now, the next thing I want to talk about, well, before I get to the American Victims of Terrorism Compensation Act, I do want to talk about the Khobar Beirut lump sum catch-up payment. So, in December 2022, Congress created a procedure and process where the GAO would determine the amount to be paid to certain victims of the 1983 Beirut barracks bombings and the 1996 Khobar Towers bombing. And this lump sum catch-up payment would go to these folks, notwithstanding whether they had gotten money from other sources outside of the fund. Only in the last month, I believe it was within the last month or possibly a month and a half, GAO issued its preliminary final report. So it said, we believe that the percentage is going to be, honestly, I can't remember what the percentage is. I remember the number, the dollar figure is around $614 million. Now, you may recall that Congress appropriated $3 billion to the fund. And if that catch-up payment ends up being in the $600 to $700 million range, anything left over from the appropriation from Congress, once those payments have been authorized, is supposed to roll over into the general fund of the state-sponsored terrorism fund. So, at the least, there would be $2.3 billion rolling over once those payments are instituted for the Khobar and Beirut victims. And possibly more because since that money was appropriated within the 9/11 community, it was introduced in the House in May of this year. One of the biggest issues with the fund has been its inconsistency in funding to allow meaningful distributions on an annual basis. So this new law is intended to address some of the funding issues that have plagued those distributions. The ABTCA would seek to mandate that the penalties from Binance and BAT, British American Tobacco, be paid into the fund in their entirety on the premise that if a case involves any portion related to a state sponsor of terrorism, then the entire penalty should be provided to the fund. It would also provide access to excess balances of the Department of Justice's Asset Forfeiture Fund and the Department of the Treasury's Forfeiture Fund. Now, these excess balances are not always the same year over year. They fluctuate, but they would provide a jolt of additional revenue annually into the fund, likely into the hundreds of millions of dollars. The act would also require additional transparency by the fund, both to Congress and to the public. And honestly, we've seen some of those changes to the public recently as the fund has revamped their website. Their case deposits page now shows case deposits, the amount of money deposited, what fiscal year it's deposited in. It gives you a little bit more of an ability to audit what they are receiving into the fund to know, okay, I saw that OFAC issued this penalty. Did that penalty get deposited? Well, you can look on the case deposits page, find the company, and look at the amount of money and compare it to what the amount of the fine was. And so that's been a helpful change in the way that the fund has been operating and being a little bit more transparent in its actions. Now, one criticism that has been raised about the ABTCA is that it amends the fund statute to make the even split, the 50-50 split between the 9/11 related claims and the non-9/11 claims permanent, and therefore harms the 9/11 plaintiffs because they have significantly higher overall claims amounts. The problem with this line of thinking, and I understand where they're coming from, I understand the desire to increase what the 9/11 side of the equation receives, but the problem with this is that in 2019, in November, the Clarification Act was passed. In the Clarification Act, it was the first time that 9/11 victims, spouses, and dependents were allowed to participate in the fund, and it was there that the 50-50 split was created and was supposed to move forward into the future. The ABTCA is not creating something new. It's simply clearing up the language from that 2019 Act that ended up being kind of a mix and match of the original law and the amendment and made it a little bit more clear. Again, I understand where the folks are coming from who want to see that 50-50 split goes away, but as I said earlier, I don't think the 50-50 split is going to be an issue in probably 2 years. I think there's going to be an equalization between the two sides of the fund, between the 9/11 related claims and the non-9/11 related claims. So we still support, we at Motley Rice still support the ABTCA. At the present time, we're awaiting it to be marked up in the House Judiciary Committee, and we anticipate that's going to happen very soon. And while the fund has a number of issues that it does not address, the ABTCA addresses one of the biggest issues, which is there just hasn't been enough money. With that, I'm going to turn it over to Terry. I know there's going to be plenty of questions because there's always a lot of questions about the fund, but Terry, I'm going to hand it back over to you.
Good afternoon. Thank you once again for having me. My computer failed me this morning, so I'm going the old-fashioned way. I wrote down some notes, so just bear with me, please. I am Terry Strada, the National Chair for 9/11 Families. I am here to update you on the legislation and what is going on in Congress down in Washington, D.C. As we're all aware of the Justice Against Sponsors of Terrorism Act, JASTA, that passed in 2016, and what its goal was to get the 9/11 families to have our day in court, and that is exactly what has happened with JASTA. All of the evidence that you heard today, the slides that you've seen, the things that are coming out in the future are all because of JASTA. So I am so pleased to say JASTA is working, and thank you everyone that supported it in the 7 years that it took to get it enacted. However, it was great. However, in order for JASTA to be applied correctly to our case against the kingdom, we need a technical fix bill, and that is called the Ensuring Justice for Victims of Terrorism Act. It is now sitting in Congress in both judiciary committees, in the Senate and in the House. It is needed in order for us to hold the kingdom accountable. You can learn more about the EJVTA by going to my website, 911familiesunited.org. You can also see the evidence that was presented today, or what the FBI has allowed us to see up till now. The website has been visited over 17,000 times this year alone, so I know you're looking, and I encourage you to continue doing so. With the EJVTA sitting in the Judiciary Committee for the past year, it's been slow and painful to get them to move it. But I am pleased to tell everyone here today that it will be marked up in the Senate next week. That is big news. I urge you all to go to the website. There you will see letters that you can send into Congress. Once you put your information in, a letter will be sent to your representative, to your 2 senators, and to both committee chairmen's offices. This started about 10 days ago, and we've had over, what's the number? I wrote it down somewhere. Well, we've had thousands, let's put it that way, responses into Congress, which is probably helping with the Senate making a move on it. The more letters that go in, I hope to hear that the House is going to follow. If the House chooses to follow the way the calendar is set up, they would actually go one day ahead of the Senate next week. So that would be a home run, and that is what we are pushing for. So the website is an informational hub. I do not send out newsletters and updates, so I encourage you to go look at it frequently. You can also sign up for the newsletter. You can learn, like I said, about everything that's going on in Congress. I try to keep it updated as much as possible, and the letters are working, so let's keep them going. Oh, here's the number. 3,500 letters have gone in the last 10 days. That's awesome, and I thank you. Lastly, and this is really quickly, all of this does cost money. The website, the material I use, the trips I take to DC, I think I've been there at least 8 times since we last spoke, and I'll be going down next week to follow up on all of this. Anything you can do, there's a donation page now, is greatly appreciated, and it does help. As always, I wish everyone as much peace tomorrow as we possibly can have, and love. Thank you.
Thank you, Terry. Thank you, John. Thank you, Duke. With the time we have left, I think there's a few questions, some time for question and answer session. And we've done a collection of questions that you all had sent in to us, and maybe we can start with a few of those. First thing I would say, though, is that the website that Terry mentioned has a very easy ability to go into it and send those letters into Congress regarding the EJBTA. Do that. They've made it very simple. You can go in, you just put in a few pieces of information. It takes probably 2 minutes to do, maybe a little bit more. Go ahead, do it. It's very simple. Get it done. Make sure Congress hears the words of you folks to know that you support EJBTA. What I like to do is for the questions that we have, maybe front end some of those questions that may be pertinent to John Eubanks, since he's not here. And if we have any questions that run over past the time, maybe some of us might be available afterward to answer some questions. Some of the questions, but the first question I see that I think I'm going to ask John to address is, are cross-border victims, or I think that would be non-U.S. nationals, treated differently from American victims or U.S. nationals? 2 similar cases having very different results. John, can you address that?
The short answer is yes, because unfortunately the primary statute that we use, and I'll address this first to Iran, and then I can address it to the Saudis and everybody else, but the statute that we've used to sue Iran primarily is for U.S. nationals. It is for U.S. nationals harmed by an act of terrorism committed by a state sponsor of terrorism or with support from a state sponsor of terrorism. What we have argued to the court on those cross-border or non-U.S. national victims is that JASTA, which is a different section of the Foreign Sovereign Immunities Act, JASTA actually allows people, notwithstanding their citizenship, to bring claims against a terrorist sponsor or a state sponsor where the attack happened in the United States. So we've gotten the court to adopt that theory, and then it rolls over into what can you sue them under. You sue them under state law, and what the judge has done has been to generally issue identical judgments for identical type claims. Under state law and under the Foreign Sovereign Immunities Act law. When we have submitted those claims to the U.S. Victims of State-Sponsored Terrorism Fund, they are balking at the non-national claims because there is language in the statute that says that the act out of which your claim arises must relate to the removal of sovereign immunity under the U.S. national only issue. And they said yours relates to JASTA, which isn't the other. It's a confusing mess, and like I said, that issue is on appeal to the special master right now because it's just wrong. Because there were Americans and non-Americans killed, the acts giving rise to claims were subject to the terrorism exception that deals with U.S. nationals, and JASTA. Now, in the other cases, under the Anti-Terrorism Act, under JASTA, generally the claims of non-nationals are going to proceed under state law in the same way that they would under the other provision against Iran. So they're going to proceed under state law, but what the judge has shown is that he's willing to look at the cases in the same manner between state law, whether that's New York or the place of the attack generally is what they're looking at. So under the state law in New York, Pennsylvania, or Virginia, and treating it the same as they would under a case under the Anti-Terrorism Act, which again has the U.S. national requirement. So yes, they're treated differently. The outcome should be the same, and we're trying to work to make sure that outcome is the same.
So I got one more question for you, John. Well, what happened to the $3 billion from Afghanistan that was frozen? And I know that's not Iran related, but I know John's the one from Motley Rice who addressed the motions against the Taliban that we had. So I'm going to refer to John and allow him to address that one as well.
So, as we all know, judgments were entered by Judge Daniels against the Taliban, and a number of different firms sought to collect on those judgments against the Taliban using those frozen funds that were at the Federal Reserve Bank in New York. Judge Daniels determined that he couldn't make those funds available to judgment holders against the Taliban because the money frozen in the Federal Reserve Bank is the money of the central bank of the real government of Afghanistan. And if you were to say those were Taliban funds, that would be the court recognizing that the Taliban was the legitimate sovereign in Afghanistan, which is something that only the executive branch can do. So, in short, those monies are still sitting in the Federal Reserve Bank. The issue was appealed to the Second Circuit, and we're awaiting a decision because it's a situation where certain parties somewhat related to the Central Bank of Afghanistan intervened in the case to argue that it shouldn't be released, but really there wasn't a whole lot of argument on the other side, and the judge simply decided this of his own accord, following some hints that were given to him by the Department of Justice. So we're waiting to see what the Second Circuit does. I don't have great optimism because there is some logic to what Judge Daniels said and what Judge Netman had recommended to him. And I can see the Second Circuit reaching the same conclusion that that money needs to be set aside until the U.S. recognizes a government in Afghanistan so that the money can go back to the Central Bank of Afghanistan. So it's a difficult situation. We have these judgments against the Taliban that currently have no money to collect against them. But it was important to get those judgments, if for no other reason than now Saudi Arabia knows the value of the case. They know the real value of the case based on economic reports for estates and across all of the different plaintiffs in the cases. So that's a positive, but it may not be a positive for those $3 billion.
So the next question that I have is Sudan deemed back on the list? What does that mean, and what happens next? And I think the answer is Sudan's on the list, and that's the list of state-sponsored terrorism. But it doesn't affect the claims in this case, because the claims in this case predated them being on the list, off the list, and on the list. Do I have that right? And maybe they're off the list now. They're off the list now.
They're off the list now, but they're on the list for purposes of this MDL.
So for purposes of this MDL, the fact that they were on the list at the time, that's what governs. The fact that they got off the list doesn't change that circumstance for us.
Correct.
Now, is there any questions in the room that we have? I have a few more here, but yeah.
Is there any effort to be taken to bring parity to the children and widows of 9/11? Because the in-laws have been paid 18%, The non-9/11% are at least 24, 28% of their judgments, and the children and widows are at 6%.
I think first thing you have to look at is the value of the judgments, and the value of the judgments are what the values are. In terms of the percentage, I'm not sure when you're saying the percentage, the values that are getting paid are proportional to what is in the, and I'm assuming you're talking about payments from the fund, correct?
The U.S. fund, right, and I'm talking about the judgment value.
Well, the judgment value is what the court's determined. So we can't change what the value, we the lawyers can't change the value that the court has set in entering those judgments. And that there were claims by different groups, and they included the estates, they included the spouses, they included the children, they included the salation claims by the, well, I guess the salation claims include claims by the spouses and by the children, but also by other family members, or immediate family members. So the values that were set by the court aren't really something that we can change. And the percentages, as I understand, John, you can correct me if I'm wrong, but the percentages, they don't change as a result of what the relationship is from the fund. The fund pays out based on a set percentage that they're paying of each claim. The percentages of the dollar value look different because the judgments are different, correct?
Well, let me interject one little caveat to that. The only people who are at that higher percentage are those who were able to participate in round one. Now, round one was the round where it was paid out at 13.66%, I believe. Only slightly more than 400 9/11 related claimants actually participated in round one, whereas now we have over 12,000. So to kind of respond to the question that was posed, and I think actually within that 400 may actually include some people who were not in the VCF, but went other routes and therefore kind of were able to partake even though they were the spouse or children. But it's a situation where there's a small number of people who have that higher percentage, very small number in comparison to the larger whole group. And any family member who participated in rounds 2, 3, 4, but not round one, has received less than any spouse or child or victim who has participated in round 3, the LSCUP, and round 4. If that makes any sense. I mean, I know it's confusing, but the number of people who participated in that round one was small in comparison to the larger group. So it's not a situation where all of the in-laws or siblings and parents were paid this 13.6%. It was about 400 people who were. And it's a significantly less number than how many parents and siblings are in the claims now.
So I'm told we have time for one more question, but to the extent that there are other questions, let me know, who has more questions? Excellent. You have
Hi,
one?
Laureen Salito. I am a mother, not a wife, and I don't have children. I'm talking here because it was brought up about the widows and children. I want to say to all the lawyers that are here that there are factions within our 9/11 community based on some of these issues. And I am really disappointed that our lawyers, all of you that are here, are not doing something to bring these different groups to the table to try to work it out. We're going into the 25th anniversary, and if you don't think the public, the Senate, knows that there are problems and there are really differences in her opinions, I just implore you to figure out some way amongst you that you can bring these people to the table and find out what we have in common, if there's anything we can do to support each other, and move forward towards the 25th anniversary. if you don't think the Saudis know, or, you know, people know there are such differences. And I'm here because I've worked from the beginning and I understand all of these groups. And we deserve to find some way, the lawyers have to help us find some way. That's it.
Maureen, thank you. I'm not sure there's a question in there, but I appreciate
I want to know how you can do it.
Yeah, and that's the question I was going to address.
Okay.
You and I have a good relationship.
Yes.
I want us to continue to have that. I want us to be able to work through what the issue is. It's not something that has eluded us. We understand that there are differences. There are thousands and thousands of plaintiffs in the litigation. I would be shocked that there weren't different views of the different constituents that are built up in that group. I'm happy to sit with you and figure out whether there's something that you think that we can do, and I'm happy to hear other words, but it can't just be, my interest has to be met regardless of what others are. There are competing interests, and I don't disagree with you, that it'd be great if we could all work together to go after the other side. That's the goal.
Something really quickly. Since I am an advocate for the families, I can say we are united way much more than we are divided. I work with all of the groups across the board, and there is, one small faction that wants to rear their ugly head every once in a while and make it difficult for all of us, and that's just the way it is. But I'm going to say 99% of us are on the same page all the time for the same thing. We are much more unified than we are divided.
Thank you for that. And I think it is really important that we keep in mind that we have a common other side that really needs to be the consistent focus. Maureen, you're right. The other side, if they see a division, they're going to foster that. And I think that it's true that we need to keep our focus on the goal here is to make the other side accountable. If you have other questions later on, I'm happy to stick around a little bit. Duke is probably around too, so if you need us, let us know. Frank, thank you.
Yeah. Okay. Robert, guys, hang with me here for a minute. I wanted to make sure I was clear on as we return for the lunch. So we've had a great morning. Robert, thanks for hosting this. Duke, John, and Terry, it was a great job. We have to reconvene in 45 minutes. Can we do an hour? Okay, Mary says an hour. So it's 1:45. We'll come back together. Check out the tables in the hallway. Don't forget these preparedness kits. We have 500 we're going to be then making here and distributing, and you're welcome to make one for yourself. Presenters and sponsors, we're going to have lunch in the Treasury Room. Others, you've gotten a thing for Bill's Burgers. We ran out of those, so if you don't have one, there's a list of local spots you can get a quick bite in. I want to be clear on as we reconvene, we're going to come back together at 1:45 in this room, but we are going to talk to Dr. John Howard, and he's going to comment remotely. And then we get into the VCF, the Victim Compensation Fund. For those of you in attendance that are not interested, it's not an applicable subject for you, you can work on preparedness kits. And then at 2 o'clock we have two things going on. One in this room, we're going to continue the discussions on the VCF and so forth, and the compensation programs. And then over in the quiet room, which is next door, we're going to get back together with Robin, who was on first thing this morning, Ann and Virginia, on the topic of promoting resilience, healing, and wellness. So I hope that's clear. 1:30, we all come back here, 10 minutes with Dr. Howard. You can decide from there whether you stay in here if it applies to you, or you take a break and join the session that'll start at 2.